Good morning. This is the Tuesday, June 28th meeting of the Assembly Judiciary Committee. I'm Mike Fewer. I'm the chair of the committee. I want to announce at the outset that items 11, AB 642 by Mr. Padilla, and 18, SB 865 by Ms. Negrete-McLeod have been pulled from today's agenda. Why don't we hear from our first author in sign-in order? That would be our colleague, Mr. Leno. Senator Leno will be followed, if she is here, by Senators Woke and Corbett. Mr. Leno is here on two items, item 12, SB 651, and item 16, SB 850. Mr. Leno, please.
Mr. Chairman, committee members, thank you for your warm welcome this morning. If you see a smile on my face, I guess I'm still basking in the glow of the bipartisan success of marriage equality in the state of New York just a couple days ago. Though this state, of course, its legislature being the first in the nation to support marriage equality, we know the history of it, passage of Prop 8, that now being determined in federal court. When our California Supreme Court ruled that Proposition 8 was constitutional, it was specifically because the justices said that we're just talking about a nomenclature, we're just talking about a name, that because we have a domestic partner registry in California, that same-sex couples will not lose any rights, benefits, or privileges as a result of upholding Proposition 8. It's just a name. But because the court had also ruled that it must sustain strict scrutiny, that the state must have some compelling reason if it is going to treat same-sex couples differently. And we have identified a number of differences that yet exist in California law between married couples and domestic couples, and that's what this bill is about. So it has three components to it. Curiously, and I think this is somewhat anachronistic, when we did develop our domestic partner registry in the late 1990s, since it was a new concept, that the state was going to officially and legally recognize same-sex couples, we included a provision that said that before a domestic partner relationship could be certified, that the couples must share a residence for 6 months. Well, what is the compelling governmental interest in requiring that 6 months residence shared? Now, we know that there are many reasons why some couples, even if they wish to share a residence so that they can become domestic partners, cannot. They may be working in different states. One could have aged parents that he or she has to be caring for, children, studies. There are many reasons why a couple may not be able to share residence, and the question again is, what is the state's compelling reason to require that? So to treat and to sustain the Supreme Court decision that Prop 8 is constitutional, we must make sure in statute that these two different types of couples are treated equally under the law. So this would remove the 6-month residence requirement. Then additionally, there's something called a confidential marriage for whatever reasons. Heterosexual couples who wish to get married and keep it confidential have that ability. Domestic partners do not have that ability. We would equalize that as well. And then finally, the bill would permit minors to enter into domestic partnerships in the very same legal manner that heterosexual minor couples can become married, and that is with the permission of a parent or guardian and also with a court order. So written consent, court order, right. Treat them equally under the law. That's all the bill does. And I just would close by saying that, again, our Supreme Court upheld the constitutionality of Prop 8 with regard to our Equal Protection Clause. And I know the committee members are quite familiar with California's Equal Protection Clause, but quite simply it says that no citizen or class of citizen shall be granted any privilege or immunity not granted to all citizens on the same terms. And that's all this bill does. Treats everyone equally under the law. I would ask for your aye vote.
Thank you, Mr. Leno. Before we hear from your witnesses, a couple things. First, I'd like members of the audience to respect Mr. Leno and our colleagues on the dais by keeping conversation to a very low level. Second, I'd like to establish a quorum. Please call the roll.
Fewer.
Here.
Wagner. Here. Adkins. Here. Dickinson. Here. Gaines, Huber, Huffman, Jones, Monning, Wachowski.
Here.
I'll take a motion on the consent calendar. Is there a motion?
So moved.
It's been moved and seconded. Call the roll, please.
Fuhr,
Aye.
Fuhr, I. Wagner, Wagner, I. Atkins, Atkins, I. Dickinson, Dickinson, I. Gaines, Huber, Huffman, Jones, Jones, I. Monning, Monning, I. Wachowski.
Aye.
Consent calendar has been approved. Mr. Leno, your first witness, please.
Yes, that would be our sponsor, Equality California.
Good morning, Mr. Chair, members of the committee. Mario Guerrero with Equality California. We are the sponsor of SB 461, and we thank Senator Leno for authoring this bill. As Senator Leno stated, important legal differences remain between domestic partnerships and marriage under state law, and these were highlighted by the California Supreme Court case in 2008 on Proposition 8. This bill addresses the three very specific differences that were mentioned earlier, including the residency requirement, having one residence, confidential domestic partnerships, and also allowing minors to enter into a domestic partnership under certain circumstances. Because same-sex couples are prohibited from legally marrying in California, we are forced to pursue the enactment of legislation that will provide greater equality and security to domestic partners and their families. However, domestic partnerships will never offer the dignity and protections of marriage. And as long as differences remain between domestic partnerships and marriage, we are essentially in non-compliance with the law, given the California Supreme Court ruling. We respectfully ask for your aye vote to move us one step closer to equality.
Thank you very much. Are the witnesses in support of Mr. Leno's bill? Are the witnesses here in opposition to the measure? Seeing none, colleagues, questions or comments on the bill? The bill's been moved. Is there a second?
Second.
Questions, comments from members of the committee?
I have a comment.
Mr. Wachowski.
I'd like to thank you for bringing this. I'm learning a lot of things being in the Assembly. I had no idea that there was such a thing as a confidential marriage, and I didn't know about the common residence. It seems when you read the staff report and you think this is a crazy condition that you have to have for a domestic partnership. So I thank you for educating me.
Thank you, Mr.
Current law
Wachowski.
forces same-sex couples to live in sin for 6 months, and we want to do away with that.
Now, you can only have one confidential marriage, right? You're still limited to one.
correct.
They're not, since nobody knows.
That'll be the next measure on our agenda today, Mr. Wachowski. No further questions or comments. The bill's been moved and seconded. Mr. Leno, wish to
I ask
close?
for your aye vote.
All right, call the roll, please.
Fuhr,
Aye.
Fuhr, I. Wagner, Wagner, no. Atkins, Atkins, I. Dickinson, Dickinson, I. Gaines, Gaines, no. Huber, Huffman, Jones, Monning, Monning, I. Wachowski, Wachowski, I.
That bill has, that bill has 5 votes. It requires one additional one. We'll put the matter on call. Mr. Leno, your next bill is item number 16, SB 850.
Yes, when Congress passed back in 2009 the American Recovery and Investment Act, it included a portion called the Health Information Technology for Economic and Clinical Health, otherwise known by its acronym of HITECH. And this HITECH provision allocates about $44,000 for each medical provider who transitions from medical records that are written to electronic health records. And clearly that is the 21st century way of providing health care. There are efficiencies. There are, when done correctly, health benefits as well. There also will be greater incentives for providers to make this transition beginning in 2015. Physicians who elect not to use electronic health records will be penalized starting with a 1% Medicare fee reduction, and that grows to 3% in 2017. So clearly the federal government is interested in encouraging, incentivizing health providers to transition as quickly as possible to electronic health records. What this bill does is put federal regulations into state statute, which will require that any changes or deletions to health records be recorded and preserved so as to protect the accuracy and integrity of health records. Clearly, if a patient were to review current handwritten records of their health care, they would see when a change is made. We think that the very same allowance for that kind of information being shared is essential for a patient when reviewing electronic health records. There had been concern from providers at the previous policy committee, and we took amendments to neutralize all the opposition so that the current technology being used by Kaiser and some of the other larger providers would not be deemed useless with regard to the implementation of this bill as statute. So we've worked out the kinks, and we had unanimous approval in Health Committee, bipartisan support, and I would ask for your support today.
Thank you, Senator. Your first witness in support. Bill's been moved and seconded. Mr.
Good afternoon, Mr. Chair and members of the committee. On behalf of the sponsor, the Consumer Attorneys of California, and as its immediate past president, we urge the passing of SB 850, which will bring us into the 21st century. We are moving very quickly to a O's and ones, meaning that's what we're all becoming, data, binary. And there have been experiences that I'm familiar with where electronic medical records have been deleted, and there is no history of the events that occurred. We all know more about our credit history than we do about our medical history. I doubt that many on this panel or this committee have actually seen their medical records, but I've seen many. And I've seen in the past where they've been altered by handwriting, and people are able to see that handwriting change by a change in the ink, a page that's been removed, something out of sequence. In the electronic medical records, it simply disappears. It is deleted. So someone's life history, someone's medical history is deleted, and that can be a very important public safety issue because when you have a transition from one team on a shift to another team on a shift, if there's a record that's been deleted with no record of what it was, then that patient doesn't have the continuum of care needed to provide and assure that they will have the best treatment necessary. This bill will preserve whatever is changed or deleted. So not only will it be the date, time, place, and person, which is the federal standard, but California will take the first step forward in the United States to making sure that the what is also preserved, so that we will know for patient safety what occurred, what medicines were administered, and what is recommended for the future care. This is a very important public safety bill. I encourage your aye vote. I thank you for your time.
Thank you very much. Are the witnesses in support of Senator Leno's bill? Are the witnesses here in opposition to the bill? Colleagues, questions or comments for Senator Leno? Mr. Wachowski.
How is the deletion going to work? Is it going to be like, when I have a Word document, we just draw the lines through it, so I knew that this was the previous record, but I'm changing it. How is that practically going to be is it going to be a different color, or what does that look like?
The entire trail will not be immediately in front of the provider or the patient, and that was one of the amendments that we took in health because of the technological challenges to have, as we were told. Some systems have provided, some don't. So there will be the preserved trail of all the changes, but the record will still, as Mr. Dolan noted, the who, the what, and the when. So who made the changes, what were the changes, when were the changes made, so a patient could look further to find exactly what he or she needs to know.
If I may address that briefly, in the record there will be a note that something, an event occurred. Then there will be an event log, and that event log in many of these systems will automatically indicate what the event was and what the change was. So that patients can be provided both their medical record, which will note that an event or change occurred, and then a provider or a patient can go to the event log and immediately see by date and time what the event was. Have I answered your question? Yes. Thank you.
Thank you very much. Mr. Monty.
Yeah, I just want to thank the author for bringing this forward. We did have a full vetting of this in the Health Committee and some very compelling testimony from a family who the family was thwarted in their efforts to try to access medical records based on the final life term of the mother who passed away. I think the amendments that were taken did address some of the concerns of the industry, and we'll perhaps hear from that when we hear from opponents. But some of it was just the technology of existing electronic health information systems and not having to retool them all. And the amendments that were taken by you, Senator, I think address those issues, allow for the access, not the destruction, access, but not necessarily on the face of the patient chart. So I think the key is that we preserve all actions and that was achieved by the amendments that were taken. So I want to thank you for working with the hospitals and others that were concerned, but protecting this primary interest, that this is ultimately, in my view, it's not any other person's interest than the patient, and that's whose interest we're trying to protect. So thank you.
Thank you, Chair Monty. And as a result of those amendments, Mr. Chair, I don't believe you'll hear any opposition today.
Right. Thank you very much, Mr. Monning. Senator Leno. Mr. Wagner.
Briefly, and I don't mean this to sound as cynical as it probably is, but I got to ask, why is this bill regarding patient health and medical records something that's being brought to us by the trial lawyers? Where's the CMA on this? Where's the hospital association? Where's the patients' rights groups? If this were truly a problem in the healthcare industry, I'd sort of expect to see them here. It looks like it's more a problem in the legal industry, and so I guess that leads to my question: don't we already have in place in the jurisprudence area the kinds of negative inferences and evidentiary sanctions and things that that perhaps this is what is really being addressed here? Aren't those protections there?
Sure, Mr. Organ, and rest assured your question sounds as cynical as it appeared. If you look at your analysis, you'll see that listed under support is not only our sponsor, the Consumer Attorneys of California, but also the Consumer Federation of California, the preeminent consumer rights group, is a supporter of the group, as is the California Association of Health Underwriters, listed as support for the group. And the other health providers you mentioned, as a result of our amendments, are now neutral on the bill.
They're neutral. They're not.
Correct.
I guess we'll score that as a successful exchange. Well, all right. Further questions or comments for the Senator? Seeing none, the bill's been moved and seconded. Mr. Leno, do you wish to close?
I would ask for your aye vote.
Thank you very much. Call the roll.
Fear.
Aye.
Fear, aye. Wagner.
No.
Wagner, no. Atkins. Atkins, aye. Dickinson. Gaines. Gaines, aye. Huber.
Aye.
Huber, aye. Huffman. Jones. Monning. Monning, aye. Wykowski. Wykowski, aye.
That bill has 6 votes and is out. Congratulations, Senator Leno.
Thank you, Mr. Chairman. Thank you for the committee's attention.
Thank you. All right, now we have Senator Corbett, who is here on a couple different matters. She's here first on item number 6, SB 459, to be followed by item number 15, SB 823. Senator Corbett, good morning. Welcome.
Good morning. Thank you very much, Mr. Chair. Happy to be here. My first bill is Senate Bill 459.
Indeed.
Thank you very much. Dealing with the issue of misclassified employees. And I would like to start by gladly taking technical amendments that have been discussed on page 8 and 9 of the analysis. Senate Bill 459 prohibits the willful misclassification of an employee as an independent contractor, and it holds consultants liable only when they knowingly misadvise employers on this matter, and requires that independent contractors be provided with important information about their classification. When a worker is misclassified, it affects the way our California labor laws, such as minimum wage, overtime protection, workers' comp coverage, family leave, and unemployment insurance are applied. And the misclassification of workers results in a loss of payroll tax to the state, in increased reliance on state-funded public services. We have had some concerns expressed by opposition with regard to things like record keeping, and we have been asked to specifically exempt certain industries, but we think there is another way to deal with some of these issues, and we've had very productive discussions with several groups on how to make the notification and the record keeping parts of the bill less burdensome, and we believe that we're on the road to achieving some some answers to some of the concerns that have been addressed. Toward the goal, I am working with groups to look at amendments as the bill moves forward, achieving certain things. Right now, the bill requires that independent contractors be provided with information about their classification via a form developed by EDD. I will work towards amending the bill to allow that this information can be provided through inclusion in an existing document that employers provide to their independent contractors, such as a contract. So that will make the requirement less burdensome. Currently, the bill is silent on when the information must be provided, which has raised some concerns that there might be costs involved with that. So we would be glad to take a look at amendments to the bill to specify that the information can be provided to an existing independent contractor at whatever time the employer is otherwise providing written communications to their existing independent contractors. And also we have been working on the concern that the requirement for employers to maintain records is burdensome and duplicative. So I would be glad to take a look at amending the bill to specify that additional records do not need to be maintained if that information is already kept in the records required by another state or federal agency, such as maybe tax records. So these, all of these ideas are a good faith effort to address some of the objections that have been raised on this bill, and I greatly appreciate the assistance of the opposition groups and working towards identifying these issues and working on ways to make these requirements less burdensome. This bill does have support from the California Labor Federation and the Teamsters Public Affairs Council, the State Building and Construction Trades Council, the Consumer Attorneys of California, and the California Nurses Association, and AFSCME, and many others, including a growing number of businesses who are also very concerned about bad players in the industry. And members, I just want to emphasize what we're doing here is we're trying to go after people who are intentionally trying to evade the law, not people who have made simple mistakes. And there are protections in the bill that will help people who are doing the right thing avoid any problems with this measure. And with that, I have some witnesses to speak in.
Thank you, Senator. This is a concept we've heard before, as versions of this bill have passed this House a couple times in the past couple of years. Your first witness in support.
Mr. Chair and members, Caitlin Vega for the California Labor Federation. As you've pointed out, this is our fourth year addressing the issue of misclassification of workers as independent contractors. We're increasingly seeing misclassification as one of the largest threats to workers' rights. As jobs and the nature of work changes and as employers increasingly rely on contingent labor models, we see misclassification growing throughout the sectors that we represent. Primarily, initially we saw this specifically in industries like the courier industry, the trucking industry, janitorial, construction. Increasingly, we are seeing it across the board. And there's a reason for that. Misclassifying your workers as independent contractors creates huge savings. So that means that workers are not getting the wage and hour protections that they need. They're not eligible for unemployment benefits. There is no workers' compensation coverage, so they don't have that when they're injured at work. It also means that good employers who are complying with the law and properly classifying workers have to compete with those who are not and those who are making a profit through misclassification and through cheating workers. In addition, workers who are misclassified have no right to organize, have no ability to improve their lives or improve their working conditions. That's why this is such a big problem, and that's why so many of our unions are involved in this effort. One of the major problems we have with misclassification is that labor law enforcement is so inadequate. As the labor market has grown, as the number of workers have grown, there are very few labor law inspectors. Very little enforcement is being done. And so what we have tried to do with this bill is specifically think about how do we deal with this major threat to workers' rights in an era of woefully inadequate enforcement. So the first piece is bigger penalties for willful misclassification. We've defined willful as intentional, voluntary. We mean to target the true bad guys who are doing this on purpose. I know that the opposition has suggestions about how to define willful. We have tried to put a standard that we thought was a meaningful standard. In existing law, misclassification doesn't require any standard of willfulness. If you misclassify, you owe that worker all the wages that you should have paid. You owe the state the payroll taxes that weren't paid. So by putting in a standard, we viewed this as something of a compromise, as really trying to say this is targeting the bad actors, those who are deliberately doing this. Part 2, that's a notice, providing notice to that worker. Again, in an era of inadequate enforcement, when employers know that it is very unlikely they will ever get caught for misclassification, let's empower workers. Let's make sure that every worker understands that they've been classified as an independent contractor and what that means. Because oftentimes workers don't have access to that information, don't understand what that means about their wage and hour protections, about their tax liability, about their ineligibility for unemployment or workers' compensation. So let's make sure that workers have that knowledge. And then part 3, let's hold third-party consultants liable if they're running around advising employers to misclassify and getting employers in trouble. Let's try to have some accountability there as well. That was our approach. That's why the bill's structured as it is. And as the bill has moved, we've increasingly heard specifically from a few industries that the notice requirement is a really hard one for them, that they are fine with the willful provisions because they're not willfully misclassifying, but that the notice requirement is a burden. It was not our intent to create something that was really burdensome. We thought of it as, EDD makes a form, all you have to do is hand it to the worker. But as we've engaged with them and as they have, patiently explained how their industries are structured and why they feel that the existing requirement is so burdensome, we have really grappled with ways to address those concerns. We've been resistant to straight up exemptions for a couple reasons. The first is that so many industries have asked for exemptions, and every exemption you give, there's a new industry that wants one and they point to the last one, and so that's been a challenge. The second piece is it's hard for us to say, if the major objection is the notice requirement, it's hard for us to say what industries there are workers in who don't need to have that information, or who or where we're sure that there are no problems and no misclassification. I think in general, we feel like every industry has good actors and bad actors. But we have really listened to some of the concerns that they have raised, and we understand there are industries where there are legitimate independent contractors. That's the model. Everyone's happy with that. The workers want to be independent contractors. They have gone into business for themselves to become independent contractors. And so what we have tried to do is figure out ways, and we are engaging. We had several meetings yesterday. We're continuing to meet and talk to people, but really trying to look for how to make that notice requirement as unburdensome as possible. Have it in regular communications, have it as part of their regular interactions, have it included in existing contracts. So we are committed to trying to work through those issues because, again, that's not the intent of the bill.
Okay, thank you.
Thank you.
Next witness in support.
Mr. Chairman and members, Barry Broad with the Teamsters. At the end of the labor market that we're talking about where this happens, you basically have people who answer ads for jobs. They're not in business for themselves. They've never established a business for themselves, and they are forced to be in business for themselves. They are forced to go into a business against their will. This is how you work. You're a 1099 worker. They haven't put a shingle out. They don't have a business license. They haven't done any of that stuff. They don't even know about filing quarterly taxes. We're talking about situations just this year. Dealt with a situation where a major hotel chain was using a sort of a labor contractor whose immigrant Latina room cleaners were classified as independent contractors. That's what they did. And they cleaned rooms right alongside the people who were employed. It was just cheaper. Now, this is fraud, and it's fraud and it's done all the time, and it's done on the basis of entrepreneurial risk, the risk of getting caught versus the risk of how much money you save. There's no, as Caitlin pointed out, you don't have to pay the employer side of Social Security, unemployment insurance, none of it. It's a 20% premium to start with when competing against other employers. 20%. That's a lot of money. Now, it's pretty un-American to say you can force someone to go into business for themselves. People should be able to do that voluntarily. And we all know who those people are because they go into business for themselves. I did it. I get 1099s from people. I'm a real business. I did it. I invested. I'm a professional. I'm not a room cleaner who comes from another country and is told this is how you work. And that's just wrong. And it's costing our economy in California $20 billion in taxes. $20 billion. Now, wouldn't your guys' problems be a lot easier to deal with if there was an extra $20 billion floating around the budget? That's money that is owed right now for people that are breaking the law. So it's about time we do this. We need to get tough with this. Everybody in the market, they know that they're cheating. They know that they're taking the chance. But the problem is they're not worried enough about getting caught.
Thank you. Other witnesses in support, please don't repeat prior testimony.
Good morning, Chair. Simeon Gant, Service Employees International Union. And again, just wanted to say that it does become a burden on individuals who are misclassified, and we don't want to continue to burden employees who are just trying to make a living. And so, as others previously stated, we are in support of the legislation for those reasons.
Thank you. Others in support?
Patrick Henry on behalf of the California State Council of Labor. We believe that this is a fair bill that provides for notice. We think that all employers should know whether or not their employees are either an employee or an independent contractor. We believe that if an employee is classified or misclassified willfully and intentionally, that they ought to be penalized. For those reasons, we support the bill.
Thank you.
Eduardo Martinez on behalf of the California State Pipe Trades Council, the International Brotherhood of Electrical Workers, and the Western States Council of Sheet Metal Workers. This problem is particularly prevalent in the construction industry. We ask for your aye vote.
Thank you.
Kelly Green with the California Nurses Association, and we strongly support this bill, particularly in light of the increasing numbers of temporary workers that we see in the healthcare sector. Thank you.
Other witnesses in support of Senator Corbett's measure? Witnesses in opposition to the bill?
Good morning, Mr. Chair, members. Chris McKaylee on behalf of the Messenger Courier Association and the California Grocers Association. A couple of quick points. I think the bill, in an effort to go after the bad actors, as have been cited by the proponents, would be a lot easier if the law were perfectly clear. And unfortunately, the law regarding independent contractors is anything but clear. In fact, the Department of Industrial Relations website advises individuals that you may be an employee for one department and an independent contractor for another. That is the fundamental problem here, is that the law is unclear, and therefore prosecuting, if you will, the willful violator is that much harder. There are many employers in this state that act in good faith, and many individuals who know what they are doing in entering into an independent contractor relationship. Despite the statements of the Teamsters that there's apparently rampant fraud and abuse going on and forced individuals, there are thousands of individuals who believe that the independent contractor business model is appropriate and viable and ought to be allowed. The first provisions of the bill substantially increase penalties for willful misclassification. Knowledge is often cited. Unfortunately, it's in the third provision of the bill dealing with the third party who can be penalized for knowingly advising an individual to avoid employee status. We would prefer a definition on those lines than that which is in Section 1 of the bill, which defines willful as merely voluntary and intentional. The second provision of the bill deals with for notices.
Let me interrupt just for a second. Could you just repeat what you said? You'd prefer what definition over the one that says willful and intentional? It means voluntary and intentional?
In the third provision of the bill, it deals with the third-party actors who advise
Right, the
employers.
consultants, right.
The consultant community. On page 6, lines 1 through 4, it says that that person knowingly advises an employer to treat an individual as an independent contractor to avoid employee status. We would prefer a definition along those lines,
Go ahead.
requiring the knowledge.
Okay, go ahead.
The second item is the proponents claim that many individuals do not know what they're getting into. Clearly, the second major provision of the bill will advise individuals of their rights and responsibilities. What we would like to see is some benefit for the good actor. Our suggestion to the author and sponsors of the bill is to take a page that has been used for decades at the federal and state levels by the Internal Revenue Service and the Franchise Tax Board, which is to provide the factual circumstances, request a written determination, and once received, that is binding upon the parties as well as the government. Now, obviously, it would not be allowable if you withhold or misrepresent information or the facts change. But if we're going to impose additional duties, we're going to fully apprise individuals of their rights and responsibilities as independent contractors, and they can seek a written determination from the state of California, then we would like to see that be binding upon the requesters and the state, so that when you're dealing with the good actors who for years conduct themselves in a proper manner to the best of their ability to implement the often 20 different factors for determining independent contractor status, do not have the state of California come back 2 or 3 years later and reclassify those individuals. So with that, we remain opposed because none of those amendments have been accepted at this point. Thank you.
Thank you. Others in opposition, please.
Jennifer Barrera on behalf of the California Chamber of Commerce, and we're also in opposition to the bill. We agree actually with the proponents that we want to go after those bad actors because for our members who are complying with the law, it hurts them as well as they're trying to comply with the wage and hour laws and are at a disadvantage for those bad actors who aren't. The concern we have is, not to restate everything Mr. McKaylee just said, but with the willful classification, we think it can encompass the good actors and the bad actors. If it was an intentional and knowing definition with the intent to avoid the law, such as that third-party liability that we just discussed, that would help us separate the good actors from the bad actors. The alternate proposal that we have suggested is to make it consistent with the term willful that's utilized in the Labor Code and other sections. And the specific section that we were referencing is Labor Code Section 203 that deals with the willful failure to pay wages at the time of termination. That definition has been defined by the Division of Labor Standards Enforcement as an intentional and deliberate failure with absent a good faith basis in law or in fact for failure to pay or for the action. So we've proposed that definition as well to remain consistent with the Labor Code. Again, our intent to be to separate those good actors from the bad actors. As was discussed in the proponent's testimony, there are already existing penalties out there for the misclassification of an employee as an independent contractor. You can get hit with unpaid wages and the statutory penalties for failure to pay, etc. What we don't have is basically a $25,000 penalty on top of that employers have to struggle with when they are actually trying to act in good faith. And so we really want to set that line in between the good actors and the bad actors so we're not discouraging businesses from trying to comply with the law in this independent contractor classification that is so vague. And with enforcement efforts as well, that was stated by the proponents, we actually do have enforcement out there. We enacted the Private Attorney General Act that allows any individual to act as a private attorney general to go out and enforce the labor code. So there is adequate enforcement measures out there. We just need to make sure that we're using those enforcement measures to go after the bad actors. And again, until we have that clear definition between the good ones and the bad ones in this bill, we remain opposed.
Thank you. Others in opposition?
Great. Thank you, Manolo Platine, Personal Insurance Federation of California. First, just want to thank the author and the sponsor. We have been talking for a matter of months now. We don't oppose the intent of the bill. I think the question is the relevance to the insurance industry, and actually the sponsor and the analysis made good mention of our position. In our industry, no less than 6 federal courts, including the U.S. Supreme Court, have ruled that insurance agents are properly classified as independent contractors. These are individuals that own, operate, manage their own business, receive 1099 forms, and work under detailed contracts with insurers. They are professionally licensed, and this license goes with the individual, even if they sever a particular relationship with an insurance company. It's clear that these people are small business owners. They want to be. They don't consider themselves employees of, the companies, and they purposely hung out a shingle and went into business for themselves. Our concern is not on the willful standard, the beginning of the bill. Our concern is on the form, as the senator properly recognized. We consider the form unnecessary because in our world, the courts have determined that this classification is proper, so we question the necessity to send this form to independent contractors that already know they are. We do recognize the challenge of the sponsor and the author to write an exemption because we do recognize other industries are coming. Everybody's asking for it, but at this point we are unclear if there's any other industry that has a U.S. Supreme Court decision backing up our position. So finally, we just ask that, while we understand it's definitely easier and cleaner to write a very broad bill, we'd ask the committee to weigh the benefits of that kind of broad bill that includes the good actors and bad actors, weigh that with the legal traps and the administrative burdens that it puts on legitimate businesses that have a long history of properly classifying their employees. Thank you.
Thank you for your testimony. Next witness in opposition.
Mr. Chairman and members, Joanne Betancourt representing the Securities Industry and Financial Markets Association. We have similar concerns as the insurance industry. The problems that this bill is trying to address do not exist in our industry. First of all, we are arguably the highest regulated industry out there. These are sophisticated people, highly educated people, negotiating contracts between each other. They know they're independent contractors. There's no underground economy here. They're 1099. Everything was reported with the IRS. So we do feel that the additional reporting requirements, the disclosure requirements, and the increased compliance costs for securities firms without the correlating benefits to either securities workers or the securities firm just doesn't make sense, and we believe that this is unnecessary for our industry. So for those reasons, we must oppose the bill. Thank you.
Thank you. Others in opposition?
Mr. Chairman, members of the committee, Randy Pollock on behalf of the Direct Selling Association. Also very similar to the securities and insurance industry, we are opposing this bill at this time because of the notification requirements. We appreciate working with Senator Corbett. One of the issues that we have is a lot of our business are in homes. And with burdensome paperwork, what we're also concerned about is that it can be a disincentive for people to go into this business. Another piece of paper, people are going to try and figure out what does this mean to us. Additionally, it also requires under the law that if you don't provide the information that your home would be open to EDD inspection. And also you could potentially be charged with a misdemeanor. And we believe this would be a disincentive for people to go into this business. And for those reasons, we respectfully oppose the bill at this time.
Thank you.
Mr. Chairman, members, Bill Krause representing the Financial Services Institute. FSI is the Association of Independent Financial Advisors and Independent Broker-Dealers. Similar to the members of Mrs. Betancourt's organization, our primary concern is the record-keeping and notice requirements of the bill. There are about 60,000 financial advisors in the state of California. It's a very significant burden. It's a lot of record-keeping. It's a great deal of tracking, information providing. It's not as simple as it looks when you're trying to provide this information, maintain this information for a population that size. And, we think the legislation should be aimed at the problem. As was noted previously, it's very clear that the relationship between the broker-dealers and the financial advisors is an independent contractor. There's no question. It's a very stable, long-term, clear relationship that is clearly an independent contractor relationship, and placing this additional burden on what could be a relationship of 60,000 people, we just think is unnecessary and unwarranted. Thank you.
Thank you. Others in opposition?
Mr. Chair, members of the committee, Jim Ewert for the California Newspaper Publishers Association. We thank Senator Corbett for taking the amendments, which make the bill a little bit better. But nonetheless, we remain opposed and urge a vote. Thank you.
Thank you. Any other witnesses who wish to state opposition, please?
Jamie Kahn on behalf of the Associated General Contractors, and we are opposed to the bill.
Thank you. Any other oppositions?
Thank you, Mr. Chair and members. Matt Gray on behalf of Cal Small Biz. A number of concerns. Clearly, this does
increase the penalty for these offenses, and it does so retroactively ex post facto. The willful definition we do have concern with, because if you read the bill, all an attorney would have to do is actually recognize and identify the misclassification and then go back and look at the forms which were voluntarily and intentionally filled out. It's not so much an act of having guilty intent. Everyone is subject to prosecution under this measure, and we've asked for clarification on that. We think it's reasonable. Put in intent, put in guilty intent, and we think that would go a long ways towards addressing our concerns. Okay. We'll leave it at that. We thank you for your opposition. For those that give it, thank you.
Thank you. Any of the witnesses in opposition? Seeing none, colleagues, questions or comments for Senator Corbett? Ms. Atkins.
Thank you, Mr. Chairman, and I want to thank both the senator and the sponsor for taking extra time to work with me yesterday and get some answers. I guess I actually do believe there are plenty of bad actors, and I really think this is a necessary piece of legislation. Couldn't agree more. Some of the people who spoke in opposition, you know, I do have to ask if you've been working for about 3 months with some of these folks on the notification issue, where are we in that? And why are we not trying to separate out legitimate independent contractors related to the notification issue to make it less burdensome? And how do you intend to do that between now and the next committee, or where you go from here?
Well, I think the most important thing to point out is that we have had some very good conversations, and we are making progress with some groups. What would be really helpful to us, and I asked this question in one of the meetings we had yesterday, is to get more information from the various industries as to actually how their paperwork flow and what sort of notifications they are required to make already. And we've got that information from some of the industries. We need more information from some of the industries so we can figure out how to maybe take this bill, allow for a process that is part of what they already do. In other words, many of these industries, in fact, all of these industries, if they're doing business and they're licensed businesses in California, they're required to keep various types of records. If there's some way that we can have the records that we are asking for be kept, or excuse me, not be kept, but if the records that they are already keeping provide the information that we need, then perhaps we can just use that information. So that would deal with one of the issues. With regard to notification, I've listened very carefully. Various industries, communicate with their folks on a regular basis. They have various notifications that are email-oriented, and I'm sure there's some that are still required to send things by the mail. But we're glad to work with them and see if there's some way we can make the notice more minimal and make it coordinate with things that they're already doing. The concern about granting broad exemptions, sometimes things change over time. And so when we're crafting legislation, we have to think about that. So we don't want to cast the regulation in a way that we may have to change it again in a few years because people figure out a way around it. But if we can work on a way to make this less onerous, I'm very, very glad to do that. And I think there's ways we can do it. And some industry folks are coming back to us with information that will help us make this less onerous for them. And if you have conversations with any others, please encourage them to give the information so that we can do this. That's our goal. That's what I stated in my opening remarks. And we're glad to make the progress, but we need the opposition's help as well to get there.
Okay, thank you, Senator. In terms of broad exemptions, I'm not sure, I know you open the door to one, then there's another and another,
yes.
But can you comment on the insurance industry's discussion of the U.S. Supreme Court decision and why that wouldn't be broad, that would be backed up by U.S. Supreme Court decision? And I'm not an attorney, so I'm sure there'll be plenty of comments on that.
One point that I would make, and then I'll have Ms. Vega also answer the question. We may be talking about agents. We're taking a look at that. We had that conversation last night. But the concern is also agents also employ people, so we don't want to mislead people and not provide a notice and then have them dealing with other workers. They may need that information to be able to not run afoul of the law when they're hiring individuals. So we just sort of have to figure and sort through all of that and see if we can still accomplish what we're trying to accomplish. With regard to making it less onerous, we're certainly glad to work with them. The opposition and myself and the proponents are looking at different goals in this legislation, clearly. So we just want to make sure we, allow for a process so we don't have people intentionally, evading our law, and we protect people under the laws we work so hard to pass for employees.
Thank you, Ms. Atkins. Mr. Broad.
Yeah, let me just make one comment on this point. Remember that generally the employer that's taking the risk is the employer that hires the so-called independent contractor full-time to work just for them. And when they do that, and they don't designate them as an employee, they are taking a risk, a big risk at that point, because the person isn't working out in the world with multiple clients and multiple customers. They're not advertising. They're just working side by side with other people who are employees. And in that situation, an employer has made a decision based on whatever advice that they're going to take that risk. And it's a very big risk and a very costly risk. What we can't do is start making categorical exemptions that institutionalize massive amounts of conduct and bad conduct. And the example would be the insurance industry, which has had terrible problems in this area. First, they went through a round of calling everybody executives and try to get out of overtime, and then they got caught and they lost at the Supreme Court level and spent hundreds and hundreds of millions of dollars they had to pay in back wages. So now they switched to this independent contractor thing. They're running through, and that's a cost of business. These are big players. They know exactly what they're doing. So we can't do categorical exemptions for people that have a pattern and practice of violating the law, like the insurance industry.
Thank you. I think I'm trying to get to the good players, not the bad players. And frankly, I'm aware of a business that pays workers' comp, unemployment taxes, has 10 employees, had one independent contractor, is now being investigated by EDD, and the money has a pension for their staff, has health insurance, a profit-sharing plan. So I'm not trying to get at the bad players. I know they exist. You've given me case after case after case. I believe you. But my point is we're doing a broad brush to get the really bad players. And I understand how difficult it is to frame legislation in a way that gets the people who should be paying taxes, should be upholding workers' rights, and are abusing the system. But I really want to focus in on the piece that you indicated, Senator, which is how we're going to get to the things we need to do technically within the legislation to protect the people that really are playing by the rules. Right. All those other people, I totally agree with you on. So, I hope, in terms, and I do think it gets into a difficult issue when you've got independent contractors who hire staff, which was a question I don't need anybody to respond to, but in terms of my financial planner hires staff. She may be an independent contractor, but I see how complex this is, but I also think it's important for us to try our hardest to meet the intent of working with the people who do really intend to follow the law and not get caught up and ensnared in the net that costs them money, time, and keeps them from making a profit, which basically, in the case of this one business I'm familiar with, cuts into her staff's profits in terms of their profit-sharing agreement because they have to pay to go through this process with EDD. Now, maybe, there are other businesses, I'm sure. Well, anyway, you get my point. I think my other colleagues probably have questions and comments.
Ms. Atkins, Senator Corbett, if I might, we've heard, I think, almost universal agreement among all the witnesses that the intent of Senator Corbett's bill is right. We heard opponents say, we, the good businesses, to use a too simple a term, suffer because others knowingly engage in this practice, and they're purposely trying to circumvent the law, and we have to bear the burden of that inadvertently. I'm going to make a strong suggestion, and in hopes that by listening carefully to all sides here, we can move to yes on this bill. We heard opponents say, Mr. McKayle's testimony was along these lines, and others mirrored that testimony, that they thought that the definition of willfulness needed some further clarification, that mere voluntariness and intentional action might, in the words of Mr. Gray, lead someone to be brought within the ambit of the bill by virtue of purposely filling out a document rather than doing so with the intent to circumvent the law. With that in mind, I think Mr. McKayle suggested something very similar to what I'm going to recommend, which is that willful mean voluntary and a knowing effort to avoid employee status. The verbiage, I'm not going to deal with the grammar of that, but conceptually, willfulness would mean voluntary and knowing effort to avoid classifying someone as an employee for that purpose. I think that would get much of the opposition feeling, and let me put it another way. I think that the legitimate points that are made could be meaningfully addressed by importing the word knowing into the definition of willfulness. And I think the concept isn't merely knowing, but it's knowledge that one is trying to avoid employee status. I'm hopeful, and I'll hear from Ms. Huber in just one second, I'm hopeful that helps us zero in and get to yes here. Senator Corbett. I recognize it's tough to put you in a position of having to respond on the fly, but I think this is a level of discussion that we can fairly have in the committee
I don't think that's on the fly.
Okay. All right, very good.
Maybe because I feel very comfortable here having sat in your seat.
Yes.
And know how excellent your staff is, and your committee members for that matter. I think that would be fine. And I just want to clarify, are we referring to page 4 at line 21?
Correct.
For the actual definition?
That's right.
Okay. Yeah, that would be fine.
Okay. I'm going to say that should be part of the legislation. I don't want to interrupt the flow of questionings. Ms. Huber has a question. I know Mr. Wagner has a question.
Just to make sure we do the proper follow-up, can we work with your staff to have the specific grammar?
Yes, but again, the points are knowing and there's some term synonymous with to avoid employee status.
Yes.
Which is the terminology that was referred to in earlier opposition testimony that exists on page 6 on line 3.
Right. So we're exporting the part of the definition on page 6 and using it in the overall definition for the legislation on page 4.
Ms. Huber.
Yeah. Just give us the specific words and we'll be glad to.
I was already intending to offer another alternative definition when the chair suggested his, but I just want to at least throw it out there because there is established case law on what is misconduct. And I think that when we start creating definitions that aren't out there, we open up ourselves to a lot of uncertainty on how the court's going to interpret that language. So I was going to suggest that we simply insert willful misconduct in misclassification of an employee because there's a whole body of case law on what willful misconduct is. And the definition doesn't have to be in this statute because it's already developed. It's generally is a conscious or intentional disregard of the law. And I think that's what you're trying to get after. You're trying to get after those bad actors. So if we just say willful misconduct in misclassification, we know that it's not just the act of filling out a form or the act of signing a paycheck or bill, if you will, if it's an independent contractor, but just adding the word misconduct could really clarify this definition for us so that we don't have to have this fight about what does it mean, it's uncertain, the business community hates uncertainty. We could have actual established case law. So that would be my suggestion. My suggestion is at section 226.8A1, add willful misconduct in misclassification. And there is already case law. If people felt the need to define it further, we could change that D subsection on page 4, line 21, to be conscious or intentional disregard. And I think that would really just bring us within the framework of existing law and and make people feel a little bit better that we're really only trying to go after the bad actors. I had another comment on the notice issue, which I can wait till
Please.
later if you'd like.
No, I
You
think
wanna-
that's fine.
Should I respond
Keep this
to
flow.
that?
Pardon me?
Okay, go ahead. I was just going to respond.
Well, actually, I think it makes the most sense just to pause for a second, have the senator respond to your first comment, and then proceed to your second. Senator Corbett.
Yes. With regard to the definition as it is and the definition as has been proposed by the chair and the third definition.
Too many lawyers in the room, Senator Corbett.
Too many lawyers.
Yeah.
It's a good thing. I just wanted to point out that the definition that is currently placed in the bill, it didn't just come out of the sky. It actually is based on a review of statute with regard to this issue. So I just wanted to point that out. So we do have some basis for that, some underlying basis for that. It's not just something that has never been defined or might be too difficult to interpret. However, I think that what the chair has proposed may cover some of the issues you're concerned about, and we're glad to take a look at that. With regard to the case law, I haven't had an opportunity to review it, but I will gladly do that after this hearing today and see if there's pieces from that that perhaps can also, combine with what the chair suggested and see if that makes sense to go forward.
Thank you, and I do appreciate all the time that you've spent with me in talking about these various issues. And when it comes down to just changing the language, if we could change a word here and fix a lot of these problems, great, and I appreciate your willingness to do that. On the notice issue, what it comes down to me is people are concerned it's going beyond the documents they're already required to keep. So could we just change on page 5, line 5, and make it the IRS required records? Because that's one of the things that people have been talking about, that 1099s already have to be kept for 4 years. Those have all of this information of the name, address, social security number, and federal tax identification number of each independent contractor is on the 1099. So if we kept that document, it should satisfy that requirement. And since federal law already requires that you keep that, couldn't that go a long way towards clearing up some of the uncertainty the business community has on what kinds of records would be required to be kept?
Well, in my opening comments, I specifically state that I would be willing to take a look at amending the bill to specify that records don't need to be kept and maintained if they're already kept and maintained by another state or federal agency. So I would just have to specifically review I'm an attorney, sorry, specifically review the specific record you're referring to and see if that matches. But I think you and I are talking about the same thing. So I think we can get there.
Thank you, Ms. Huber. Mr. Wagner.
Thank you, Mr. Chairman. All these lawyers sitting around not getting paid, some would argue that's a beautiful thing. I think we're moving in the right direction, but frankly, I'm not convinced we're there yet. Mr. McKaylee's definition is probably good to graft into other sections of the law, but the Chamber raised problems that, or definitional issues that I think need to be accounted for. I mean, throughout the Labor Code, apparently there are other definitions of willful. I'd like to take a look at those and see if maybe there is a way to add some consistency to this provision, at least consistent with other provisions of the Labor Code. And I don't know for sure that the language we're talking about necessarily gets there. The other problem that hasn't been addressed yet, and I think is worthy of consideration, is this sort of safe harbor idea, because there are different tests, or courts, depending on where they sit, will look at different factors to determine whether one is an employee or not. What do you propose? Well, you apparently propose nothing, and I guess I would ask whether you will consider some provision in here that says the good actors who do get a determination of status one way or the other, that good actor is protected later. Again, that was one of the witnesses. I think Mr. McKaylee suggested that just to help with the fact that this is a very complicated area of the law.
My overall goal with this legislation is to craft legislation that will stand the test of time. And one of the problems with a broader safe harbor is that things change. Practices change, business models change, those sorts of things change. I have discussed the idea. I'm not quite sure if we're able to craft something completely as Mr. McKaylee is interested in it and still achieve the overall goal of this legislation. But I'll be glad to go back to him and talk with him some more about it, Assembly Member. One of the things that is already law and protection that is already available to employers is an employer can request of EDD to give an analysis as to whether they have complied with the law. And if they do that, they have the opportunity, obviously, to meet the standard that they have not intentionally or willfully tried to circumvent the law. So there are protections already in law that would protect an employer if they just request that, and that is used on a regular basis. So that's one protection that's in the law. It's not the same as a safe harbor, but it allows the evidence for someone to make the case that this law does not apply to them. So that's one protection that's already available. The safe harbor, I'm just afraid that I'm just not sure if we can find something that will withstand the test of time, but I'll go back and like a good lawyer, I'll go back and try to figure out if there's a way to do that.
Well, let me follow a little thread that you just something you just said there. If the law changes, if the underlying law changes, somebody is properly classified as an employee and the law changes.
So if a business practice changes, that's what I'm concerned about.
If a business practice changes, right? Well, but as I understood Mr. McKaylee's proposal, then it would no longer apply because the facts are different. You've got to give the agency the right facts to start with. So if the facts change, I can understand that the original determination would be different. That's already in the law. But if nothing has changed, why do we have a problem with a safe harbor?
Well, I think Mr. McKaylee's proposal specifically requests that the EDD provide the safe harbor scenario. Right? That's how it has been brought to my attention. That when EDD is making an evaluation as to whether someone's complied with the law, that allows for the safe harbor. The analysis that is done that gives the employer the information as to whether they've met the standard of the law, that information, the information that decision is based upon, is information that is provided by the employer. So it's sort of a cursory look to see whether they have complied with the law. Currently, EDD does not have a mechanism for doing a more thorough investigation, going back to determine whether the information that has been provided is accurate or is still accurate over time. So that would create a scenario where you might not be able to justify the safe harbor. It would be very, very costly at this time to have EDD develop a fail-safe situation to uphold a safe harbor at this point. So that's one reason why I'm hesitating, because what he's proposing with the department he's proposing it with, and the resources are available, it wouldn't be airtight. But glad to continue talking with him about that and see if there's another option.
I'll be brief, and with the indulgence of the chair, I may not have gotten Mr. McKaylee's proposal exactly right, or there are nuances. He's back. Does he have something to add to this?
But let me just note, we have an exceptionally full agenda with multiple bills that are going to require some wrestling. So I'm hopeful we can bring what has been an extremely far-reaching conversation to a conclusion quickly. Mr. McKaylee, if you have a concise word, fine. Otherwise, I want to move to conclude.
Well, just briefly, Mr. Chair, I mean, the way Mr. Wagner has described it, I think, is consistent. And considering that the chief counsel at the FTB, the chief counsel at the IRS does similar type activities, I think our proposal is to follow along those same lines. And the determination could be sought by the employee, the worker, the employer, or them jointly together.
Thank you. Mr. Wagner, thank you for your pro bono work. All right. So at this moment, Mr. Wojciechowski? Okay, you seem poised to say something, but very good. So we're Senator, we're at the concluding point, I think, in our conversation, and here is my attempt to summarize where we are. We have a bill, the essence of which has been passed by the legislature twice at least during my tenure.
Yes.
It is being refined. There are elements that there is an element at least that I am going to ask you to take as an amendment from this conversation, which is the definition that I suggested for willfulness. It's a definition that actually, of course, originates from the opponents today, but I think it's a constructive suggestion. We have added to that Ms. Huber's suggestion regarding the notion of misconduct. I don't know enough as I'm sitting here to know whether that is something that is a good idea to import today into the definition. But my staff will work with you, and if she wishes, Ms. Huber, but at least apprise Ms. Huber as to whether between here and appropriations there is something about that notion of misconduct that would benefit the legislation, because I think it's an important thing to us to consider. There are two other areas where you stated in particular you are involved in conversations where I don't think this conversation has crystallized enough to say with certainty what we should do. One is precisely what records should be retained. I've heard you say that you understand the point that having to retain a whole new set of records would be unduly burdensome, and therefore you're just trying to identify what are the appropriate records that are already kept that should be retained for this purpose, and that you, in appropriations, will take an amendment to specify, once that review is completed, what existing records would be retained.
Yes.
That leaves only another point, a basic, at least the major point of controversy here, and that is whether there is some accommodation that can be made for industries which are comprised almost exclusively of independent contractors. The point that simply exempting broad swaths of industries is problematic is one I understand. I don't know what to do with that, frankly, as I'm sitting here today. You've indicated that between here and appropriations, there are further steps that you will take to address that question.
Yes.
Is that a fair summary of where we are?
Yes, but specifically to the notice issues, or one of the issues that we would keep working on to determine whether we can make the process less burdensome for the industries.
Okay.
Yes.
All right.
But I think that actually sums it up, and thank you for your assistance. I'll be glad to be working with your staff.
With the amendment that you've agreed to take, plus the commitment to deal with the conceptual issues that we've just delineated, those that we've just stated.
Yes.
Do you have any further statements in your closing you wish to make?
I ask for your aye vote.
All right. Call the roll, please.
Please.
I need a motion on the bill. Second. Been moved in second. And call the roll, please.
Peer?
Aye.
Peer, aye. Wagner? Wagner, no. Atkins? Atkins, aye. Dickinson? Gaines? Gaines, no. Huber?
Aye.
Huber, aye. Huffman? Jones? Monning?
Aye.
Monning, aye. Wachowski? Wachowski, aye.
Okay, that bill has 5 votes. It's on call. It needs one more. Senator, you have one more bill.
I have one more happy little quick bill.
Okay, item 15, SB
What
823.
could be better than to talk about wonderful products made in California?
This might be a more concise conversation.
Yes. Senate Bill 823 creates a program with a Made in California label. This bill is modeled after the California Grown program, which has been very successful in promoting California produce and agricultural products. I'm sure you've seen all the cute little advertising and marketing done around this. The sales, when the California Grown program was developed, sales of produce increased by 7% at the start of the marketing campaign, and this generated close to $1 billion for California businesses and for workers, and of course was a good boon for our economy. More specifically, Senate Bill 823 would allow for a marketing agreement between the state and companies voluntarily seeking to use a Made in California label. It would authorize the agency, the Office of Economic Development, the Governor's Office, to determine eligibility standards and focus on in-state manufacturing. So there'd be plenty of opportunity for manufacturers to weigh in the development of those standards. The measure is self-supporting, and it's voluntary, and it can be a great tool to allow us to promote our high-quality products made in California. I don't have to tell you, members, that the state of our economy and our unemployment, obviously this is a great measure that can help promote our products and help promote our economy, develop a better economy in California. California, the name is known worldwide. It's a great brand name. We should use it, and we should support our businesses to grow our economy and employ our people. The bill is sponsored by the California Small Business Association and the Small Business California, and has the support of several wonderful manufacturers, several in my district, including Solyndra, Solaria, and Tesla Motors. We're going to be making cars in California. It's a very great thing. So I know Assemblymember Wachowski will be excited about this as well, since we share that part of the district. And I would just ask for your aye vote on this upbeat and happy measure.
The bill's been moved and seconded by a happy Mr. Wachowski. Witnesses in support.
Good morning, members. Lori Kammerer, representing Small Business California. We represent about 5,000 small businesses throughout the state, north and south. We're very excited to be working with the Governor's Office of Economic Development to establish the criteria and eligibility for those employers who want to volunteer to be part of this program. We urge your support, your aye vote today. Thank you.
Others in support.
Barry Broad with the Teamsters, Machinists, United Food and Commercial Workers in support. We're still the biggest manufacturing state in the United States, and we're going to be, and we're coming back.
Thank you.
Good morning, members. Mr. Chairman, Robin Black with Platinum Advisors on behalf of the California Small Business Association and Tesla Motor Corp. in support.
Mr. Chair and members, Caitlin Vega here for the California Labor Federation. We know that keeping manufacturing jobs in California is the best thing for our economy, not just for those workers, but for all the things that those workers are then able to buy and spur economic growth. So we think this is a good bill. Thank you.
Are there any witnesses who wish to speak in opposition to Senator Corbett's measure?
They already did that already in the last bill.
Yeah. Okay, members, questions or comments for Senator Corbett? Seeing none. Senator, wish to close?
I think we should brag about what we make in California. I ask for your aye vote.
All right, call the roll, please.
Fear?
Aye.
Fear, aye. Wagner? Atkins? Atkins, aye. Dickinson? Gaines? Huber? Huber, aye. Huffman? Jones? Monning? Aye. Monning, aye. Wachowski? Wachowski, aye.
Hey, that bill requires one additional vote. Senator Corbett.
Thank you very much, members. Have a great day.
Okay. All right. So with apologies to a very patient Senator Padilla, Senator Liu has arrived and is ahead of you. So Senator Liu, you're up. Senator Liu has two bills this morning. He's here on item number 13, SB 746, and on number 14, SB 757. Senator Liu, good morning.
Good morning, Mr. Chair and members. I'd like to present on SB 746. California, like many states and countries, currently recognizes that tanning beds cause skin cancer. And that's why under current law in California, you cannot access a tanning bed if you are a minor under 14. This law simply extends it to minors under 18. And it's consistent with what other countries have done. And the evidence is overwhelming. In 2009, the World Health Organization elevated tanning beds specifically to a level 1 carcinogen, the same as plutonium or cigarettes. The Federal Food and Drug Administration and the Department of Health and Human Services in the United States recognizes it as a highly carcinogenic device. And this year, the American Academy of Pediatrics recommended that we ban tanning beds for anyone under 18. Evidence shows that if you use tanning beds, it increases your chance of deadly skin cancer by 75%. This bill is, if signed into law, would be the first state to go to under 18, but currently the most progressive state is Texas, which bans tanning beds for anyone under 16 and a half. I have witnesses here in support and respectfully request an aye vote.
Thank you, Senator. Your first witness in support.
Mr. Chairman, members, Tom Riley with the California Society of Dermatology and Dermatologic Surgery. We urge you to support this bill. We believe that business can prosper and shift from tanning to something else. And dermatologists who witness the effects of indoor tanning on a daily basis are here to tell you why. With me today is Dr. Ann Haas, immediate past president of the Society. Dr. Haas.
Thank you. Most importantly, I'm a local dermatologist. I am a dermatologist for Sutter Health. My office is just down the street. I am a surgical dermatologist, and that means that my practice mostly deals with the diagnosis and treatment of skin cancer. dermatologists are seeing a disturbing trend. There is a steady rise in the numbers of young women who are diagnosed with melanoma, and we're seeing that their melanomas are in a much more advanced stage. We're also seeing them on different sites of the body. We're seeing them on the trunk and the breast and the genitalia, and those are areas which are not normally exposed to the sun, but they are exposed in the tanning booth. We know that UV radiation is carcinogenic. We know that UV radiation from tanning devices is considered to be carcinogenic. Do you know that in France, in Germany, in England, and in South Australia, you cannot use a tanning device if you're under 18? They're totally banned. In Brazil, not only can you not use them if you're under 18, but the device cannot even be sold in Brazil. There have been several recent studies which have clearly shown to both reiterate and strengthen the association between the use of tanning devices and the development of both melanoma and non-melanoma skin cancer. And I appreciate the position you're in. The studies are confusing, aren't they? The older studies were a little softer, and the scientific community realized that, went back to the drawing board and designed studies trying to overcome some of those earlier deficits. And I think that they have done a very good job, and I think they have really very solidly proven the association between ultraviolet exposure and the development of subsequent skin cancer, both non-melanoma and melanoma. As a dermatologist, I thought that everyone knew this. Recently, I was in the position of looking a 21-year-old tanning bed user in the eye with her mother in the corner, telling her that she had an intermediate level melanoma. Her mother, who is a nurse at Sutter Memorial, was sobbing in the corner. The 21-year-old was sort of clueless. She just didn't really get it. But her mom did. And her mom just said, gee, I thought they were safe. So I thought about that, and I went home, and I said to my 15-year-old daughter, okay, go online. Let's decide that we're going to set you up for tanning, and let's see what you come up with. So she came up with Bronze Buns Tanning Salon. There are a number of, it's a chain, but there are some local affiliates here. And she ran off the parental consent form for me. Here it is. Okay. It takes up barely half a page. And it says that I understand and am aware that a tanning salon is potentially hazardous, and that I release a tanning salon from all liability and all risks of injury. And that's kind of all it says. However, on the bottom it says, for information on tanning, go to tanningtruth.com. So I did that while my daughter was busy printing out the other thing she found just above the place where you print out the consent form on this website was 15 reasons to tan. So she was busy printing that out. And I went to tanningtruth.com. And what I found was a very confusing review of some of the older studies with data taken out of context. I found that dermatologists were actually the cause for the development of melanoma because we treat psoriasis patients with light boxes in our offices. And truth be told, there is no study that shows that treatment of psoriasis patients in a doctor's office using a medical light box increases the risk of melanoma at all. I also found out the Dermatology Academy apparently is taking lots of money from sunscreen companies. Well, the Academy of Dermatology, like everybody's academy, has very strict rules on who they get money from and what that money is used for, and that is most certainly not the case. I also found out a lot about vitamin D. And you've heard a lot about vitamin D. Certainly it is the case that we need to have an adequate amount of vitamin D. But there are no conclusive, reproducible studies, get that word reproducible, reproducible studies that show that a lot of vitamin D is helpful for things like cancer. Okay? Actually, there are a few studies that will show that it is helpful for certain medical conditions, but you will also find studies that say absolutely the opposite. So the medical community is not in a position of being able to say one way or the other. We certainly know and advocate that people have a normal level of vitamin D. How can you get that? Okay? Diet to a degree, but also vitamin supplements. They're easy, they're cheap, $20 a year is not a problem. Actually, to use a tanning booth to get vitamin D is very inefficient. The reason for that is because most tanning booths emit UVA or blended UVA UVB. And it's actually not UVA that induces vitamin D in the skin. It's UVB.
If you could conclude your testimony, please.
Yes, thank you. The last thing this patient's mother said to me was, why don't you do something to get the kids out of the tanning booth? So I'm here doing what I can, and it is up to you to try to help us reduce the risk and get the kids out of the tanning booth.
Thank you. Next witness in support.
My name is Samantha Guild. I'm a patient advocate with AIM at Melanoma. We're a co-sponsor, and we strongly support this bill.
Ryan Spencer on behalf of the California Medical Association. We support the bill.
Deanna Furman on behalf of the California Nurses Association, also in strong support of the bill.
Alicia Sanchez with the American Cancer Society, in strong support of the bill. This would really help decrease melanoma, and we urge your support. Thank you.
Others in support? Are the witnesses here in opposition to the bill?
Yes.
Apologize, also in support. Kirk Blackburn, Ellison Wilson Advocacy on behalf of the United Nurses Associations of California Union of Healthcare Professionals, in support.
And Andrew Kiefer with Blue Shield of California, and we're in support of the bill as well.
Okay. Now, that's exhausted our list of supporters. Now, witnesses in opposition. Please come forward.
Here or stand here? Or?
Sit next to the senator. Please.
I'm sorry, go ahead.
No, please go ahead.
Thank you very much, Mr. Chairman, members of the committee. My name is Joseph Levy. I'm Executive Director of the International Smart Tan Network, which is the educational institute for the North American sunbed community. For 19 years, I've developed UV training materials for thousands of tanning professionals, and as the association's chief scientific liaison, a longtime member of the American Society for Photobiology. We're opposed to Senate Bill 746 because the bill will not accomplish what its proponents hope. In fact, it will accomplish the opposite of what they hope. Number one, professional sunbed centers in the United States use an FDA-created exposure schedule that gradually provides a suntan while minimizing the risk of sunburn. The system we have in the United States is unlike anywhere else in the world where a lot of this research has been conducted. We have the most conservative exposure schedule approach and apply it differently than the rest of the world. Is more of a home sunbed situation where the units are unmonitored and they were put forth in the therapeutic environment. Tanning beds were developed because they do make vitamin D. You heard a dermatologist just testify that they emit mostly UVA. Outdoor sunlight is mostly UVA and has a small UVB component. Sunbeds mimic that. A tanning bed will make up to 20,000 units of vitamin D in a single session for a fair-skinned person. They are the most efficient source of vitamin D probably in the world, but they're very similar to sunlight. Obviously, she didn't understand that. If this bill is enacted, what's going to happen is 14 to 18-year-olds will either spend excessive time in the sun or will purchase unregulated home tanning equipment. You're going to create an underground tanning industry. We've seen it other places. It's going to happen. Please check eBay or Craigslist. The units are out there. They will be sold, and so people could use these in an unmonitored situation. Now, this is very important because the proponents have cited one statistic saying that there's a 75% increase in risk for melanoma for sunbed users who start using sunbeds before age 35. In fact, what they haven't disclosed about that data is that half of the cases in that analysis, it's an analysis that the World Health Organization's a working group did. And the working group was 12 people. Half of those cases were people who either use sunbeds or medical use of sun equipment. Dermatologists do use sunbeds, the identical equipment, to treat psoriasis. And there is a study. Dr. Stephen Walter did a study in Canada that showed that the medical usage of sunbeds to treat psoriasis actually had a higher increase in risk than sunbeds used in suntanning centers. Our exposure situation is much less aggressive than what dermatologists do using sunbeds. They intentionally induce a mild sunburn, whereas we maximize our exposure at 3/4 of what would be required to make a sunburn through the schedules that we've constructively worked with FDA to create. Okay, so most of the risk is with home units. In the data of the studies that were mentioned by the proponents. And that's even more significant when you consider that the peer-reviewed research has also showed that if you take those studies and you remove the fairest skinned people we call skin type 1, Skin type 1 can't tan without burning. We do not tan these people in the United States. They do attempt to tan worldwide in other places where sunbed usage is considered a therapeutic activity. Sunbeds were created in Northern Europe to induce vitamin D production, and people with fairer skin were using them for those reasons in other parts of the world. We don't tan them here. We successfully screen them out using the Fitzpatrick skin type system, which our industry developed in a Fitzpatrick questionnaire in combination with Dr. Thomas Fitzpatrick, who designed the system. So the data referenced by the proponents do show that the unregulated usage and even medical usage of sunbeds have higher risk than what commercial sunbeds, okay? If you remove the commercial sunbeds and you remove the type 1s, the risk goes down to no greater than 6%, including the type 1s. So the risk goes down to something that, you know, we need more than just the vitriol that sunbeds are in the same carcinogen category as plutonium. Birth control pills, sawdust, wine, fish are in the same category as plutonium. To suggest, and we've done some research this year that our tanners are starting to bounce back from this overstatement of risk from proponents of bills like this, that they realize that it's just that ridiculous, and so they're no longer listening to you. You need to bring that level down to something that is constructive, not over-preaching risk.
Okay, if you could conclude your testimony.
Absolutely. The medical community worldwide, including much of the dermatology industry in other parts of the world, are starting to acknowledge that there are benefits to regular UV exposure, and that their statements need to be put in proper context, not made to sound like plutonium. Now, I would be perfectly willing to work with the senator on something more constructive at building better enforcement mechanisms to enforce what we already have in place without adding a new regulation that's going to cost this state money. We would be very happy to do something constructive. But what we're seeing here, it just needs to stop. This is just noise.
Thank you.
Thank you.
Other witnesses in opposition?
Good morning, Mr. Chairman, members of the committee. My name is Marty Sloan. I'm a key account manager for Heartland Tan. I've been there at the position for approximately 25 years. We distribute and manufacture tanning equipment nationwide. Also, we distribute lotions, lamps, and supplies, including the standard warning signs that all salons display in their facilities. My company employs at times 10 to 15 people here in the state of California. I'm here today in opposition of SB 746 because this will have a direct impact on tanning salons and my company as well. I have worked with tanning salons across the United States, and I can tell you that SB 746 will hit these businesses hard, especially while trying to recoup from this economy that we're weathering right now, as well as the federal tax just imposed. If SB 746 is passed, we estimate that this will reduce business by 5 to 10% in the 800 to 900 salons here in California. Based on projections from salons, we've estimated this will mean a reduction of $11 million in taxes statewide as a result of lost sales tax, corporate income tax, and payroll tax. Salons will have to let employees go, which will mean a reduction in personal income tax as well as higher unemployment in California. This, as I just mentioned, is on the heels of a federal 10% tax imposed in our health care reform. In 2004, when teens under 14 were banned from salons, the parental consent requirements were instituted for from 14 to 18. The industry was happy to comply. No business owner would allow teens to tan without parental consent due to liability reasons. In 2007, the law was beefed up, requiring that the parents provide the consent in person and would have to come in every year to renew that consent. The salons have complied with this requirement and have electronic forms that we use to obtain and store the parent signatures and other information to ensure that we only allow teens with consents in the salon. We recognize the concerns expressed by the proponent salons have been very serious about the current regulation. They post the necessary warning signs, and they have systems to ensure that parental consent is obtained prior to tanning. We are a professional organization and a responsible organization. We care about our customers. We make sure that they are protected and do not burn. For these reasons, I urge a no vote on SB 746.
Thank you. Others in opposition?
Thank you, Mr. Chairman, committee members. My name is Len Bickford, and I'm the owner of Club Tan in Napa. I'm here to oppose SB 746. In just a short amount of time, I was able to collect letters of petition from a lot of parents and customers in my salon. And the general opinion is that this decision should be left to parents to decide. The current laws do allow for the parent to revoke that authorization at any time. So I would just like to represent myself and those customers and oppose this legislation. Thank you.
Thank you very much. Others in opposition?
Thank you. My name is Tom Matley. I'm a small business owner here in Sacramento, California. I actually own a tanning salon. We oppose this bill. The current law that's in place, Mr. Liu actually drafted, and we worked with him. I testified during the last committee hearing, and we were more than willing to work with him on that particular issue. Right now, we do a great deal of business or work with our minors that are coming in using our tanning facilities. We do require parental consent. Our parental consent is actually definitely quite a bit longer than the one that was presented here. And we also require that the parent or the guardian actually be physically in the store to sign the parental consent so that we can have discussions with them in regards to the tanning process and address any concerns or questions that they may have. So we really feel that the existing law that we have definitely is adequate.
Thank you. Others in opposition?
My name is Lori Matley. My husband just spoke, and I'm here as a parent and a salon owner to oppose this bill.
Thank you. Others in opposition to Senator Liu's measure? Seeing none, questions or comments for the senator for members of the committee? Mr. Wagner.
Thank you, Mr. Chairman. And I've struggled with this one and very much appreciate the senator's time yesterday in helping walk me through it. We do, as a society, pass laws to protect kids 14 to 18. We just had a helmet bill get out of this committee not too long ago. Obviously, cigarettes and alcohol are banned. And so it's not a stretch to me to consider this, but I guess I would ask the senator, in light of some of the testimony we've heard about parents coming in and having to renew in person, what evidence is there, or why is that insufficient to shift the burden where it belongs to the parents?
Sure, I'm happy to answer that. And that's correct. I authored a law in 2007, and there's a study from San Diego released this year showing parental consent laws do not work, specifically tanning beds. One reason it doesn't work is because exactly the testimony you hear today, such as the very first witness who was telling you tanning beds help you. They give you vitamin D. They're good for you. So when our doctor testified about the Bronze Bound Salon, and she talked about the button that you click on above parental consent that says, more facts on tanning, let me tell you what it tells you. It says, when you do tanning beds, it reduces heart disease, prevents diabetes, helps prevent multiple sclerosis, prevents cavities, reduces risks of cancer, boosts fertility, and helps you lose weight. Just false. And so you have tanning salons simply lying. And so that's one reason parental consent doesn't work. The second really is, I brought the bill to ban in 2007 under 18. It was the best I could get out of the Senate at the time. But it's always troubled me, how can a parent consent to have their kid get cancer? And something you might want to consider is everything the opposition said today on facts, they not only were they wrong, they were so outrageously wrong that the federal government sued them in 2009, the Federal Trade Commission. In 2010, the Indoor Tanning Association, who is listed, by the way, as an opponent of this bill, settled and said, we will not make the following false statements, such as indoor tanning is approved by the government. So the FDA has not approved this thing. That indoor tanning is safer than tanning outdoors because in indoor tanning facilities, the amount of ultraviolet light is monitored and controlled. False. They can't say that. That vitamin D has been linked to decrease the risk of cancers. They can't say that. So the Indoor Tanning Association actually isn't here today because they're scared of saying that to you because they know they'd be in violation of a Federal Trade Commission order. So they sent these folks. This is on page 4 of the analysis. It's a really well-written analysis. I thank your staff for doing it. Just read it. And so that is why parental consent doesn't work, because you have a huge amount of false information being presented to parents and their children. And it's the same reason we don't consent to have children buy cigarettes or buy a bottle of whiskey. And so hopefully that's answered your question.
Thank you.
A follow-up, but I do think there was somebody in opposition who wanted to address that, if I may, briefly.
Thank you. Is there a salon that has made that claim that you just said was made to?
Well,
now okay. You just heard proponents of the bill say that sunbeds don't make vitamin D, aren't a good source of vitamin D. That's completely erroneous.
It isn't what he said.
What the doctor said was that sunbeds are not an efficient source of vitamin D. What our industry does not make these types of claims in the salon. It's not the intention of the salon to do this. The salon can say, and in fact probably needs to say, that tanning is a very significant production of vitamin D. I think down the road you'll see this because people are taking. You're saying it's not a source of vitamin D?
Let me. Excuse me.
I'm just saying you can't say.
Pardon me, Senator. Yeah. As the chair of the committee, I'm not going to sanction the exchange that the witness sought to elicit from the senator.
My apologies.
If you wish to answer Mr. Wagner's question, do so. We have a long agenda. Let's get to the point.
Thank you. The point is, the salons have to say they make vitamin D because so many people are taking high dosage supplements of D now that those supplements could become toxic at some point and cause people's vitamin D levels to go much higher because you make an incredible amount of vitamin D. A tanner's vitamin D level is about 42 to 49 nanograms per milliliter. A non-tanner's is about 23. An outdoor worker is somewhere around 40 to 50 as well. So tanning is consistent with a natural outdoor environment. We don't condone the usage of saying what vitamin D does, but it is a source of vitamin D production. And the response earlier you heard about that tanning is mostly UVA and that's why it doesn't make vitamin D is completely lacking in understanding of photobiology that the sun is very similar to. That is my point. They are making misrepresentations in being proponents of the bill. We should have a discussion. I've never met the senator, and I'm the Educational Institute for the Market before I introduce
Mr. Wagner. That's fine. And one other issue that has troubled me a little bit is the issue of unintended consequences. It would not surprise me at all if the incidence of mostly probably young girls between the ages of 14 and 18 now end up at the beach or out in, or the park or wherever, and sit and bake for a couple of hours in an uncontrolled circumstance and burn. Why is that not a legitimate concern?
Thank you for that question. And I forgot to mention this in my opening. There is an equally attractive alternative known as spray tanning that many of these salons have. We're just saying for this subset of people between 14 and under 18, just shift them to spray tanning. I'm a little disturbed, I know this, but Snooki on Jersey Shore switched to spray tanning. You have lots of celebrities switching to spray tanning. The Kardashian sisters have designer spray tans. It's a coming wave, and we're just saying to these teenagers, look, just get a spray tan because we don't really want to increase your chances of skin cancer.
Will they be in the building in the first place if they know they can't go there for a tan? Will they just go to the beach anyway?
So let me just flat out say I'd rather have them go to the beach because I have a witness here who will say that that's actually safer than doing intense high-burst UV ray salon.
Thank you. Thank you, Mr. Wagner, for having the committee get to the Snooki part of the presentation. Colleagues, nothing else? All right. Is there a motion on the bill?
I'll move the bill.
It's been moved. Is there a second? Mr. Liu, wish to close?
Just briefly, it is of all women who die of skin cancer between 25 and 29, of all cancers, skin cancer is the highest. Respect request and I vote.
Call the roll, please.
Fuhr?
Aye.
Fuhr, aye. Wagner? Atkins? Atkins, aye. Dickinson? Dickinson, I. Gaines. Huber.
Aye.
Huber, I. Huffman. Jones. Monning. Wachowski. Wachowski.
The bill has 5 votes, requires one more. Senator, you have one more bill?
I do.
That is item number 14, SB 757. Please.
Thank you. Let me thank the chair and committee for their work on this bill. Let me accept the amendment suggested analysis to clarify the intent of the legislation. Basically, this bill closes a loophole where out-of-state insurers are not following what California insurers have to do in terms of providing benefits to those who are in domestic partnerships. And so currently insurers under this law, under our law, have to provide the same coverage to domestic partners that they provide to a spouse. This makes out-of-state insurers do the same thing. I have witnesses here in support. Respectfully request an aye vote.
Move the matter.
Okay. Billman moved and seconded. Your first witness, please.
Hi, Matthew Bunch here on behalf of Equality California. We're proud to be the sponsor of this legislation, and we would ask for an aye vote.
Thank you. Any other witnesses in support? Witnesses in opposition? Colleagues, questions or comments for Senator Liu? Seeing none, Senator, wish to close.
Respectfully request an aye vote.
Call the roll, please.
Fuhr.
Aye.
Fuhr, I. Wagner. Wagner, no. Atkins. Atkins, I. Dickinson. Gaines. Huber.
Aye.
Huber, I. Huffman. Jones. Monning. Wachowski.
Aye.
Wachowski, aye.
All right. That bill has 4 votes, requires 2 more. Senator Padilla. Senator Padilla is here on item number 4, SB 293, and on number 18, SB 859. You are a patient man. Welcome.
Thank you very much, Mr. Chair, members of the committee. Let me begin in presenting SB 293 by accepting his author's amendments, those that speak to Section 2 of the bill. The bill should look familiar to a lot of you. It was nearly identical to AB 2216, which was approved unanimously by this committee last year and approved unanimously on the Assembly floor. The bill seeks to address payment issues in the construction industry for a very important reason. As our economy continues to struggle to rebound, we know that one way to help an industry that has been impacted far more than most is to allow contractors to be paid promptly for their work and to ensure that enough capital is available to successfully complete projects. To do so, this bill would accelerate progress payment schedules from 10 to 7 days. It would exempt laborers from having to file a preliminary bond notice. It would require subcontractors to file a late or non-payment claim prior to the completion of the work, and it will limit retention withholdings to 5% on public works projects, just as the UC system and Caltrans already does. I've already, I believe, addressed the Section 2 question, which is discussed in the analysis. Let me just introduce on behalf of the Council of Laborers, Patrick Henning, as well as Plot Gladfelty on behalf of the Associated General Contractors of California.
Thank you. Your first witness in support, please.
Mr. Chairman, members, Paul Gladfelty representing the Associated General Contractors. As Senator Padilla indicated, this is a policy issue that's been heard by this committee on more than one occasion. We believe that it's a good compromise bill that allows for increased payments of progress payments, deals with an issue that's been around for a long time, dealing with bond claims that we believe that we have an agreement with. Certainly the subcontractor community on what they're going to be represented here today. And then also on the 5% retentions. We believe that the 5% retention is one that's not uncommon in the public sector and allows for greater cash flow, especially for the contractors and subcontractors at a time when we really need it. With regard to any opposition that may be with regard to that 5% retention issue, keep in mind that that's why you have bonding. That's why you have surety bonds. That's why you have provisions in there that if there's any dispute, they can withhold 150% of that dispute until that dispute's resolved. So there's lots of protections for the public entities on this area of the law. Thank you.
Thank you. Others in support?
Patrick, on behalf of the California State Council of Labor, we sponsor this bill to help protect
the laborers' historic exemption from filing these notices in agreement with our contractors, and hopeful to bring some prompt payment to our contractors and subcontractors for those reasons.
Thank you. Others in support?
Mr. Chair, members, Chris Walker on behalf of the California Association of Sheet Metal Air Conditioning Contractors. The 5% retention is absolutely essential at this time. Typical profit margins on projects are down to 2, maybe 3%. We're having to actually capitalize our project until after the project has been completed. As small businesses, we no longer have the equity lines to be able to pay for our materials and our labor and everything we need to do. We need that money as we're moving forward. The opposition has said that if they can't hold 10%, that we'll walk off the job and we'll leave a job incomplete. That's just not true. If we were to do that, our bonds would be exercised. We would lose not only the assets of our businesses, but our homes. We would also lose our licensure with the state for the Contractor State Licensing Board without a bond. So we need this money to be able to capitalize the projects and keep our workers employed. Thank you.
Thank you. Others in support?
Mr. Chair, members, Cesar Diaz on behalf of the State Building and Construction Trades Council, also in strong support of this legislation. First of all, on the 5% retention, we definitely agree with Mr. Walker's comments. It frees up the money so that the contractors and subcontractors can bid on other work. Right now we have 35% unemployment. It's imperative for our members to get back to work as soon as possible. These are signatory contractors, so if they're not bidding on jobs, our members don't have the opportunity. And on the second part, on the schedule of payments, it's very important for us to receive for our members to receive the payments on time. So the relationship between the contractor and subcontractor is important. Thank you.
Thank you. Others in support?
Mr. Chairman, members, Eddie Bernacchi on behalf of the National Electrical Contractors Association and the California Legislative Conference for the Plumbing, Heating, and Piping Industry. For the issues that were mentioned by Mr. Walker and Mr. Diaz regarding the 5% retention, we feel this is very important. There's already precedent in codes of holding lower retention. Caltrans already holds 0% retention for the last 4 to 5 years. The University of California has changed within their general conditions their retention holding to a 5% cap. We met with them 2 weeks ago, asked if that has been a problem for them in getting projects done. Their answer was unequivocally no, that hasn't been a problem. And so for those reasons, we would ask for an aye vote.
Thank you. Others in support?
Bob Houston on behalf of the Concrete Contractors Association in support specifically because of the retention issue.
Thank you. Others in support?
Mr. Chairman, member Scott Governor, on behalf of the Construction Employers Association, this does represent a compromise measure. Our primary interest is the preliminary notice provision, having that end at the completion of the project versus 75 days after. We think that's very important so we can not have claims go against our bonds that we don't know exist. So for that reason, we do support the bill.
Mr. Chairman, Kevin Pedrati representing the Engineering and Utility Contractors Association in support of the retention.
Thank you. Others in support? Are the witnesses here in opposition? Please.
Mr. Chairman, members, Tom Duffy for the Coalition for Adequate School Housing. We're in opposition to this bill. We're opposed unless amended. And the issue for us is the 5% retention that has been discussed. On the way up to the hearing this morning, my good friend Mr. Bernacchi basically said, you're a glutton for punishment coming up opposing this bill again because this ran through, I'm assuming he was thinking it ran through the Senate and it certainly went quickly through the B&P committee. But we're here in opposition because we believe that this is, you've heard it, essential that it be reduced to 5%. We believe it's essential for public agencies to be able to retain up to 10%. Now, what is the issue? The issue for us is that the 5% is an option currently. So that if indeed, you've had a lot of discussion this morning about bad actors. Well, in school districts and public agencies, we deal with good actors as contractors and bad actors. One of the means, one of the tools in dealing with a contractor that's recalcitrant and not doing what they're supposed to be doing is to basically withhold that full 10%. In working with a good contractor, and I've done